I'm joined today by Phillip Kruger, one of our directors in our legal department. My name is Liz Pinnock. And I thought today, Phil, what we'd have a chat about is mergers and acquisitions, and particularly looking at issues around data privacy. And we know how topical it is at the moment. And I know that you've done a lot of work both within the data privacy space itself as well as POPIA for our clients, and I thought it'd be quite nice for us just to have a general discussion around it.
Absolutely.
So one of the things that I'd like us to share with everyone is, does data privacy requirements impact M&As?
Absolutely. I think that can be answered positively without a doubt. Certainly, I think the case of Verizon acquiring Yahoo brought that to the fore quite beautifully.
Yeah.
In 2017, Verizon intended to acquire Yahoo, and during the due diligence phase, Yahoo disclosed certain data breaches. As a result of that disclosure, the purchase price for the acquisition, which was set at $4.8 billion was reduced with $350 million
Sure.
which is a significant amount.
Yeah, it's a huge discount.
Absolutely. And to add insult to injury, Yahoo retained 50% of the future liability in respect of those data breaches.
Sure. So the reduction in the purchase price didn't manage to avoid that potential liability that was there.
Absolutely not.
Yeah.
Absolutely not. So it's contingent liabilities going forward.
Yeah, exactly. Wow. So with that in mind, how do you then navigate the data privacy risk during an M&A? I mean, we advise on M&As quite a lot, and one of the things that we do in terms of the due diligence process is to try and guide our clients through what can be quite a minefield, Phil.
Absolutely. Listen, I think due diligence is key there.
Yeah.
And as part of your due diligence, to specifically then focus on industry-specific policy and industry-specific legislation.
Right.
Here in particular, I'm thinking of hospitals, restaurants, gymnasiums, public spaces such as theatres. They'll each have a set of sector-specific policies that they would need to follow with regards to data privacy, particularly in a post-COVID-19 environment. One would also then have to look at what the contractual sensitivity of that specific target entity is to determine whether their customers would be extremely sensitive to certain changes in their agreements, and also to the information that they share with the target entity. And then lastly, one would have to consider the labor side of things. So one would have to look at whether there's continuing claims going on, how we would have to structure employment agreements to deal with data privacy and the like.
And that sounds very soundful. And if I was the acquiring company looking at the target, what would be the key questions that you would want to ask in that position?
I think the very first question you should ask is, what are we exposed to?
Right.
So what's the information that we do process? What's necessary and what's nice to have? Once we have that answer, we need to look at what is already in place in respect of protocols and mechanisms in order to process that information.
Right.
Then we would also have to look at the contractual sensitivity of the customers within the environment. How sensitive are the customers of the target entity? And will so-called data provisions spook them? Then we would also need to look at the labor environment. What labor disputes do we currently have in respect of data privacy? How do we need to amend the employment contracts to cater for data privacy going forward? So all of it really impacts the whole of the business.
Yeah, and that's what I was going to say to you. It's almost like you're not only looking at commercial aspects, but you're looking at labor aspects, you're looking at IT issues. It's across every operational function within that business.
Absolutely, absolutely. It goes from an operational IT perspective to a legal perspective to a risk perspective. And you really can't leave any stone unturned.
Okay. Phil, having chatted to you now around issues of data privacy, if you were advising the acquiring company, and the acquiring company were to say, well, we're not really interested in issues around data privacy, What would be your advice to them around those issues of risk when looking at the target?
Well, I think firstly, one needs to acknowledge that there's significant risk.
Right.
The immediate consequences one would think about would be civil claims that would be forthcoming from data subjects who would be the victims of a breach.
Right.
But then also fines and penalties could be imposed by the regulator. But even more so, there's a reputational risk to the acquiring company that it would, in essence, be taking on. And lastly, they might be overpaying for the target entity. They may never have set the purchase price at the level where they set it had they known that these claims would be forthcoming.
Yeah, that would be very truthful. And I suppose those claims, they could be contingent. They don't necessarily have to be evident at the time and in the heat of those negotiations.
Quite right.
And that's the risk, isn't it?
Quite right. Absolutely right, Liz. You would ultimately have no way of determining whether the claim would be forthcoming or not without having taken into account the data privacy requirements at the time of due diligence.
Right. So I suppose our best advice would be do your due diligence properly, tick.
Absolutely.
Where you can, get the appropriate warranties and indemnities.
Absolutely.
From the target company, and to some extent, maybe even keep a portion of the purchase price in escrow should one of those claims come out of the woodwork, really.
That would certainly be advisable.
Right.
All of those suggestions would be absolutely appropriate in the scenario.
Okay, that's grateful. Thanks. And I suppose then coming from that, and we've had the due diligence and we've applied our mind, how does data privacy risk impact that deal structuring then?
I think the most important part we need to look at is how to structure our deals from a mergers and acquisitions document perspective.
Right.
So particularly, again, I think conditions precedence is very important in this regard to ensure that the right systems are in place before the deal actually becomes effective.
Okay.
And then also, of course, to make sure that you have your warranties and indemnities on a back-to-back approach there.
Yeah.
How do we deal with what we are being told in respect of the information provided to us?
Yeah.
And how do we indemnify ourselves, and how do we structure those liabilities between the parties in respect of those items that we can't address in respect of conditions precedents and terms that form part of it?
Yeah, because I mean, often, Phil, well, not often, but sometimes we know that the target company would then try and make specific disclosures around certain things, well, certain, let's say, breaches in terms of data privacy. And as the acquirer, you then have to say, well, am I prepared to accept those disclosures?
Quite right.
Or are we going to say, okay, we'll accept the disclosures, but we still want a guarantee.
Quite right.
Yeah.
Absolutely, you are so correct. It's a pragmatic approach.
Yeah.
And as we saw with Verison, for instance, a sliding purchase price there was used to ensure that there's an equitable result.
Yes.
So certainly there are various existing deal-specific mechanisms to use that could cater for the scenario.
Yeah. Well, Phil, thanks very much for your time. It was great to discuss these issues around data privacy in the context of mergers and acquisitions. We know since July 2021 that the issue of data privacy has become extremely important in the marketplace, and this will continue to impact commercial transactions between parties.